When there are substantial discrepancies between the officers who recover drugs and the criminalist who tests the drugs, does that render the evidence inadmissible at trial? To find out, you have to read People versus Baez, but it's 24 pages. Don't have time for that? I got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of People versus Baez. The citation for this case is 2024 New York Slip Opinion 02225, published by the New York Court of Appeals on April 25th of 2024. The issue in this case is whether evidence that's offered of contraband, of drugs, that has extensive discrepancies in the testimony of the recovered evidence, is that legally sufficient to allow it to come into evidence? Does it go to weight or admissibility, essentially? The background that's helpful to understand this case is that before a court can accept into evidence objects that are recovered from a defendant that are found at the scene of a crime, there has to be a foundation presented. The foundational presentation has to include that the object that's offered into evidence is the one that was recovered and that it's in the same or substantially the same condition as it was when it was recovered. So it's the identity and the condition. In the case of a fungible item, if it's a painting, it's easy, right? It's easy to identify it. But if it's something that's fungible, like a marble or drugs, so in the case of a fungible item, the sufficient foundation is provided when all of those who have handled the item identify it and testify to its custody and unchanged condition. Sometimes there are gaps in the chain of custody, and those gaps, this is the background still, the gaps are not necessarily fatal, and they can be excused when the circumstances provide reasonable assurance of the identity and unchanged condition of the evidence. The gaps then go to the weight, not the admissibility. So the primary question when determining whether the foundation has been established is whether, during the gaps in the chain of custody, some unknown party, an individual not called for questioning and assessment, could have caused a material and prejudicial change in the condition and nature of the evidence. That's the background. Okay. So what are the facts here? The facts are that on February 4th of 2014, at around 11 p.m., two NYPD officers pull the defendant over while he's driving a car, because he's driving a car while using a cell phone, which is a vehicle and traffic law violation. They pull him over, and when they speak to him, officers Lewis and Lynn observe the defendant had bloodshot, watery eyes, slurred speech. They smelled marijuana. They suspected he might have been driving under the influence of some intoxicating substance. They ask him to step out of the car, and they search, and they arrest him. They then recover. They put their pocket inside of his jacket, and they recover a clear plastic bag with a white substance that fell on the ground. The defendant then allegedly stomped on the bag to try to destroy the bag and the evidence, dragged it with his foot before being moved away by Officer Lewis. Officer Lynn then retrieved the bag, which Officer Lynn testified had been torn, scooped everything up, put it into a latex glove, tied the glove, brought the defendant to the precinct, and brought the evidence, importantly, to a room where there's an officer guarding the room, and the Officer Lynn then put it on a table because the NYPD wanted the officers to go back out on the street. And at the end of the tour, Officer Lewis came back, found where Officer Lynn said the evidence was, completed the vouchering process, sent it in. 3 days later, and here's the important part: it was examined by criminalist Osorio, and the description that the officers on the scene gave did not match the description Officer Osorio, the criminalist, had. Specifically, the officers on the scene recovered drugs that they said weighed 9 grams in total. Criminalist Osorio said the whole thing weighed 5.53 grams. Officer Lynn and Lewis said there was a torn bag that they vouchered. Officer Osorio said there was no torn bag. Ultimately, there's a hearing. They offer this into evidence at trial. There's an objection being made. The Supreme Court allowed into evidence. The defendant was found guilty, and the defendant then appealed, saying this was improperly admitted into evidence because of these discrepancies. The appellate division unanimously affirmed. The appellate division affirmed what the judge had done, holding that the evidence was legally sufficient, and the foundation was legally sufficient to establish a chain of custody of the cocaine, and that the circumstances provided reasonable assurance that the identity and the condition were unchanged. But it goes to the Court of Appeals. And here, there's a majority and a dissent. The majority agrees with the judge and the appellate division. They say that in this case, they say if a gap is brief and a logical explanation is given for inconsistencies, like a torn bag, not torn bag, the weight being different, substantially different between the recovering officers and the testing officer, then it's okay. It goes to weight, not admissibility. They ultimately met their burden of identity and the substantially unchanged condition. They say that because there was a legally sufficient, because the identity and the condition have been met, it goes to weight, not admissibility. There's a strongly worded dissent here from Judge Rivera and Judge Wilson that say the discrepancies here lead to an inexorable conclusion that they failed to establish that this is the same thing that was recovered, that the identity fails here. So to basically appreciate them, but the majority here is that it was legally sufficient, and that's the case of People versus Baez. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.